This is crazy.
You've created the problem you have, not me.
I object to this whole hearing. Let's go. I'm done.
All right, Mr. Walker, please prepare another order on contempt.
Any suggestion?
Warning, this starts strong.
Ms. Kennedy.
Your Honor, do you want me to swear in?
Yeah, do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Baldwin was arraigned on July 5th, 2024 on a down file from Superior Court. He pled guilty and was sentenced to active probation in order to report to probation on Monday, July 8th, 2024 at 9 a.m. Mr. Baldwin had failed to do so. Probation reached out to the real team if they saw him to have him report, but as of that date yesterday, Mr. Baldwin had failed to contact probation. I asked for the warrant because I actually was going to just set these on the 17th where his other pretrial cases are, but I asked for the warrant because I got a call from Sergeant Greenspan at approximately 11:06 yesterday morning. He reported that they received a call that reported a naked black man on the beach before Nifty 50s that was masturbating. When officers arrived, they found Mr. Baldwin laying on the beach with his pants open with an empty bottle of wine. So I issued,
which is number one, wrong.
And he is into the community. I also want to just say that this morning I had asked for, actually yesterday after work, I had asked the jail staff to have him do a UA, and Mr. Baldwin has refused. I have not been able to put that or file that within the violation.
Okay, thank you, Ms. Kennedy. Mr. Ashcraft?
Your Honor, at this point,
No, he's got,
where we are.
so all I have is the down file, the down file with the sexual, the assault with the sexual motivation. The other ones are all on pre-trial on the 17th.
But he was to check in with probation on July 8th on those pretrial cases.
On the
as well.
pre-trials too, yes.
So just kind of a mixed argument. On the one where he's on active probation, the presumption of bail is, not there anymore. And I just bring up, he's continually just not complied. The court has done everything it can to try and help Mr. Baldwin comply, and he has done nothing to comply for more than a day since this most recent batch of issues arose. I know he's in need of both substance abuse and mental health, but we can't even get him to the door, let alone through the door to get him into compliance. So I would ask for $25,000 bail on the case where he's on probation and $2,500 for each of the ones that are pre-trial, and that we set this for, what was it, the 17th, have everything on the 17th to address it then.
I will say, Mr. Ashcraft, that just to make sure that the record is clear, on the assault in the 4th degree, the judgment and sentence requires that Mr. Baldwin not use alcohol, marijuana, or non-prescribed controlled drugs, that he is to provide a PBT, UA, or BAC upon request, and not go to places where those items are the major item of sale. However, it does not require a substance use disorder treatment evaluation at this time, just a mental health evaluation that can always be readdressed at probation hearing if we need to do so. Ms. Kennedy, did you have anything that you wanted to add for conditions?
Your Honor, I do think that he needs to be held on bail, and we really, I care about Mr. Baldwin. I want him to get held, but he's never complied. We've let him out, I don't know how many times. It's got to be 10. And he's always supposed to come and see me.
How about you guys just fucking leave me alone?
If he doesn't.
I don't want to be in the court system. I'm not doing anything wrong. Leave me the fuck alone. These fucking street cops are following me everywhere I fucking go. How come you guys don't see the legal part of it? I don't understand. You guys just sit on your asses and don't see the legal part of it, of how I'm being harassed.
Mr. Range?
Thank you, Judge. I'll reserve on argument. I'd ask that case be heard sooner than Wednesday, potentially Monday. I can conference with Mr. Charlton about.
Okay, so is Mr. Charlton still on the assault in the fourth degree case?
Well, I just know he managed that resolution in this
He did,
case, and it's his handwriting all over the judgment sentence and the like. So I'd like to work with him since it seems like he's been most recent attorney of record working.
Okay, that makes sense. Thank you, Mr. Range. Okay, Mr. Baldwin, I am going to be holding you on bail. The amount of bail in the case ending in 268, so that's the post-conviction case, will be $25,000, and the other cases will be $2,500 each. There will be cash options with each of those cases. If you are released, you are to meet with probation Monday at noon. I am going to set a hearing. Well, actually, strike the whole probation thing. I'm going to just set a hearing for 1:15 for you on Monday, and we can see what needs to happen at that point in time. We can discuss conditions of release or whatever else we want to do.
He was dry humping all that, dude.
Oh my God.
Yeah, that's what I was saying. He was getting after it when I pulled up.
All right. Hello, Mr. Pride. My name is Magistrate Winsemius. We are going to be proceeding with the arraignments. You have 5 different files today that I am going to read to you. I also have a staff member from the Public Defender's Office present. And so she is here just in case you wish to speak to anybody. So I wanted to make you aware of her presence as well. So at this time, I'm going to proceed with case number 240543FY, in which it is alleged that on January 19th of 2024 in Gunplain Township here in the county of Allegan, you did in count 1 engage in a willful course of conduct involving repeated continuous harassment of Melissa Kellerman, the conduct being such that would cause a reasonable person to feel terrorized, frightened, or intimidated, threatened, or harassed. Said conduct actually causing Melissa Kellerman to feel terrorized or frightened or intimidated or threatened or harassed, and the defendant has previously been convicted of aggravated stalking, contrary to MCL 750.411I. That is normally a felony punishable by up to 5 years. However, you do have a habitual offender notice in which it is alleged that you have at least 3 prior convictions for other felonies. On February 9th of 2015, aggravated stalking. On February 9th, 2015, delivery, manufacture of ecstasy or MDMA. And on or about February 21st of 2023 of operating or maintaining a drug lab. Therefore, count 1 is punishable by up to life. Count 2, you are accused of threatening or intimidating, discouraging, or attempting to discourage an individual from attending as a witness, testifying, or giving information at an official proceeding, contrary to Michigan law, that is witnesses bribing, intimidating, or interfering. That is normally a felony punishable by 4 years or $5,000. However, because of the habitual offender notice, as indicated just a moment ago, that is punishable by up to 15 years in prison. Will indicate on that case, bond has been set at $25,000 cash or surety. At this time, that bond will continue. It is a protective condition of bond in which you may not have any contact, either direct or indirect, with Melissa Kellerman. At this time, I know that you haven't been screened by the Public Defender's Office. So we are going to indicate that this is being set for a preliminary examination. You do have dates for that. July 18th is the date of your probable cause conference in front of Judge Scotchulis in courtroom A. Your preliminary examination is currently scheduled July 23rd. That will be in front of Judge Belargin in courtroom B. At this time, I do not have you represented by any counsel, so you are proceeding as representing yourself at the moment. If at any time you change your mind about that, you are able to contact the Public Defender's Office for further information. Now, I'm sorry? You would like to be screened for a court-appointed attorney?
I said that I have a hired attorney.
You have a hired attorney?
Yes, I do. I have had one for months.
Okay. The court has not received any kind of an appearance from an attorney. So legally, your attorney must file an appearance on your behalf in these cases to be your attorney of record. So I would encourage you to continue to contact your attorney to let him know the court has not received any paperwork indicating that you have a private attorney at this time.
You guys have me on lockdown here where I just have to keep these phones up for an hour, so I can't get in contact anyone.
Okay. All right. I'm going to continue going through this arraignment portion. And then you will be able to talk to the deputies about the fact that you need to contact your retained attorney. I just wanted to make you aware that we do not have.
That will do me no good.
Okay. I am moving on to file number 242078 FY.
I'm not guilty on all of them. I'm good with it. I don't need to hear it.
I've got to arraign you on these, sir. I've got to go through these. This one occurred on May 6th of 2024. It is alleged it occurred on May 6th, 2024 in Otsego Township here in the county of Allegan. And it is alleged on that date in count 1 that you did assault, that you did resist and obstruct a police officer, or let's see, identified as Ross Meislowick, a sheriff or sheriff's deputy of the county of Allegan, that you knew or had reason to know was performing his duties. That is normally a felony punishable by up to 2 years or $2,000. But again, this is indicated as a habitual offender notice that you have at least 3 prior convictions for other felonies. January 17th, 2003, attempted possession of methamphetamine. January 17th of 2003, child abuse in the 2nd degree. And February 21st, 2003, operating or maintaining a methamphetamine lab in violation of Michigan
This is, of course, Alyssa's fault.
law. Therefore, this is subject to up to 15 years in prison on count 1. Count 2, another count of resisting or obstructing a police officer. This time, Jacob Gage, a sheriff or sheriff's deputy of the county of Allegan, that you knew or had reason to know was performing his duties. Again, normally a 2-year felony or $2,000 fine. With habitual offender notice as previously read, this is punishable by up to 15 years. In count 3, a 3rd count of resisting or obstructing a police officer, this time a Dakota Tatro, a sheriff or sheriff's deputy of the county of Allegan, that you had reason to know was performing his duties. Normally a 2-year or $2,000 felony, but with the habitual offender notice, that is punishable by up to 15 years in prison. In this case, your bond was set at, it looks like $1,000 cash or surety. That will be continued at this time. This is going to be set for an exam. You've got a probable cause conference next week on July 18th in courtroom A in front of Judge Scatulus. Then your preliminary examination is scheduled for July 23rd in front of Judge Belargin in courtroom B. Moving on to the 3rd case. This is file 241030 FY. It is alleged that on or about March 1st of 2024 in Gunplain Township in the county of Allegan, in count 1, you did engage in aggravated stalking by engaging in a willful course of conduct involving repeated or continuous harassment of Melissa Kellerman, the conduct being such that would cause a reasonable person to feel terrorized or frightened or intimidated or threatened or harassed, and that the conduct did actually cause Melissa Kellerman to feel terrorized, frightened, intimidated, or harassed, and that you've been previously convicted of aggravated stalking. Again, normally a felony punishable by 5 years or $10,000, but with the habitual offender notice. And sir, this is not whether it is true or not, it is what's being alleged. Okay, I wanted to make sure you understood. And then that you were previously convicted of 3 or more prior felonies, February 9th of 2015 of aggravated stalking, February 9th of 2015 being in possession of ecstasy, and also on February 21st of 2020. Sir, I would ask you not to talk about the charges at this point, like no factual basis. And then on February 21st of operating or maintaining a drug lab, therefore count 1 is punishable by up to life in prison. And count 2, it is alleged that you did make an assault on Melissa Kellerman with a dangerous weapon, a pistol, but without intending to commit the crime of murder or inflict great bodily harm. That would normally be a felony punishable by 4 years or $2,000, but with the habitual offense notice, as previously stated, that is punishable by up to 15 years. In count 3, it is alleged that you did, with intent to use the weapon against another, go armed with a pistol. That is normally a felony punishable by 5 years or $2,500, with the habitual offender notice as outlined, that is now punishable by up to life in prison. And then finally, in count 4, that you did carry or have in your possession a pistol at the time that, or you attempted to commit or did commit a felony aggravated assault. That would normally be punishable by, and that is punishable by up to 2 years consecutive and preceding any term of imprisonment imposed for anything else in this case. Your bond will be continued on this at $100,000 as previously set. This is a protective condition of bond in which you are not to have any contact, direct or indirect, with Melissa Kellerman. You do have next court dates for this. That is, mark this, July 18th. You have a probable cause conference with Joseph Scotchulis in courtroom A, and a preliminary examination on July 23rd in courtroom B. And let's see. Okay, I understand. We have to indicate what you've been charged with, sir. In file 242773FY, it is alleged that on or about June 23rd of 2024, here in the county of Allegan, that it is alleged that you did make an assault upon an individual, Dylan Kibbe, with the intent to do great bodily harm less than the crime of murder. That is normally a felony punishable by up to 10 years or $5,000. But again, this is a habitual offender notice that you have at least 3 prior convictions for other felonies, including on February 9th or 2015, you were convicted of aggravated stalking. On February 9th of 2015, you were convicted of controlled substance delivery manufacture. And on February 21st of 2003, you were convicted of maintaining a lab. Therefore, this count is punishable by up to life in prison. In count 2, it is alleged that you made an assault upon Dylan Kibbe with a dangerous weapon, that being a motor vehicle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That is a felony normally punished by 4 years or $2,000, but with the habitual offender, that is punishable by up to 15 years in prison. In count 3, it is alleged that you were the driver of a motor vehicle to whom a visual or audible signal by hand, voice, emergency light, or siren by Dylan Kibbe, a police officer who was in full uniform, and the officer's vehicle was identified as a police vehicle acting in the lawful performance of his duty, directing you to bring your motor vehicle to a stop, did willfully fail to obey that direction by increasing the speed of the motor vehicle or attempting to flee or elude the officer, and the violation resulted in a collision or accident. That would normally be a felony punishable by up to 5 years or $1,000 plus a suspension of your license. With the habitual offender notice, as previously stated, that is punishable by up to life in prison. In count 4, it is alleged that you did willfully and maliciously destroy or injure a marked police vehicle belonging to the Allegan County Sheriff's Department. That is normally a felony punishable by up to 4 years or $5,000. With the habitual offender notice, again, that is now punishable by up to 15 years in prison. Bond has been set in that case at $100,000, which will be continued at this time. That also, let's see, that also contains a condition that no firearms or dangerous weapons are to be possessed and that you cannot leave the state of Michigan. You have next court dates on this. Again, July 18th, probable cause conference in courtroom A in front of Judge Scotchulis. Preliminary hearing July 23rd in courtroom B in front of Judge Belargin. And finally, this is the last file.
But has the court established jurisdiction? That's what I want to know.
File 240519FY. It is alleged that on or about January 18th of 2024 in the city of Otsego in the county of Allegan, He did engage in aggravated stalking, again, a willful course of conduct involving repeated or continuous harassment, in this time of a Jesse Null, the conduct being such that would cause a reasonable person to feel frightened or intimidated, threatened, or harassed, and that such conduct did actually cause Jesse Null to feel frightened or intimidated.
Wait, is this a different victim on aggravated stalking? Because I see why he's tired. Like stalking one person would be too much effort, but stalking two people?
Threatened or harassed, and that you had previously been convicted of aggravated stalking. Normally this penalty is up to 5 years and or $10,000, including a probation for any term of years, but not less than 5. This also has a habitual offender fourth offense notice. So again, 3 previous convictions of felonies. January 17th of 2003 for child abuse in the 2nd degree, February 9th of 2015 for the offense of aggravated stalking, and finally February 9th of 2015 for delivery, manufacture of ecstasy or MDMA. Therefore, count 1 is punishable by up to life in prison. In count 2, that is a count of bribing, intimidating, or interfering with a criminal case in which the case was punishable by more than 10 years, that by threat or intimidation, you did discourage or attempt to discourage an individual from attending as a witness, testifying, or giving information at a criminal case where the crime was punishable by a maximum term of imprisonment of not more than 10 years. This would normally be a felony punishable by 10 years or $20,000, and a consecutive sentence may be imposed for any other conviction.
I love you if you're watching.
They're not watching.
Unfortunately, because of the habitual offender notice, this is now punishable by up to life in prison. In count 3, against aggravated stalking, did engage in a willful course of conduct involving repeated or continuous harassment, this time of Melissa Kellerman, the conduct being such that would cause a reasonable person to feel frightened, intimidated, threatened, harassed. Said conduct did actually cause Melissa Kellerman to feel frightened, intimidated, threatened, or harassed, and you had previously been convicted of aggravated stalking. This would normally be a felony punishable by up to 5 years in prison or $10,000 and probation for any term of years, but not less than 5. But with the habitual offender, as previously outlined, this is punishable by up to life in prison. In count 4, you are accused of bribing or intimidating or interfering with a witness, that you did by threat, intimidation, discourage, or attempt to discourage an individual from attending as a witness, testifying, or giving information at an official proceeding. Normally a felony punishable by 4 years or $5,000, but with the habitual offender notice, this is now punishable by up to 15 years in prison. This is also, so this bond is set and will continue at $50,000 cash or surety. This is a protective condition of bond in which you may not have contact, direct or indirect, with either Jesse Null or Melissa Kellerman. You may not go where they live or work or contact them. You do have next court dates on this as well. July 18th is your probable cause conference in front of Judge Scotchulis in courtroom A. Your preliminary examination is scheduled in front of Judge Belargin on July 23rd in courtroom B. The jail will give you copies of all of these dates and times, and the jail will also make you available for all of these dates and times. And at this time, your arraignment has concluded, sir. Thank you very much, and thank you, Ms. Mickelson.
In May, I think it was. So, Mr. Orsak, I see you're there. Can you hear me and see me and all that?
Yes, Your Honor.
Okay. And can hear and see Mr. Staten?
Yes, Your Honor.
Mr. Orsak, Mr. Staten, everybody can see each other, right? Okay.
Yes.
And he's interrupting again. All right. So this is case 37284. And we're here to claims ready for trial. So Mr. Orsak, again, to be sure, you all were here earlier in May, and I hope everybody's ready. But Mr. Orsak, you're ready to bring your case forward?
Yes, Your Honor.
Okay, so you're not going to say, oh, wait, I needed to bring that witness, or I needed to get this document or something. You're ready to go to trial today, right?
Yes, Your Honor.
Okay, good to hear. And then Mr. Staten, the same question. You're ready to defend against this suit today?
Yes, Your Honor.
You got all the information and all the statements and, here with you, not to go find somewhere? Okay, all right, because today's the day, not tomorrow. So you'll notice me looking back and forth to these screens. Our
Yes.
files are electronic now, and so I'm opening them. And I have a screen here and a screen there to see Mr. Orsak. And so I'm listening. I may be looking at something over here that you filed or one of you filed as we go, but let me get that file open here. Get the exhibits out. Yep. Okay. So another question I see only, make sure I got this right. All right, let me put you all under oath and then we can get going. Mr. Orsak, there in Zoom, why don't you raise your right hand with me? Mr. Orsak, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Yes.
Mr. Staten, thank you. Why don't you raise your hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Thanks, Mr. Staten. So I see a lot of information from the plaintiffs here, and I see you've got a big file in front of you, Mr. Staten. Nothing in the court file that the court could have reviewed beforehand. Are you going to be referring to things in that file?
It depends. I'm not even sure why I'm here, other than I know I have a fence.
Okay, I thought you all talked about this in Dispute Resolution Center with them.
No, ma'am.
Well, then,
I know it says on the court papers, personal property.
well, slow down. Did you or did you not, Mr. Staten, talk with the mediators before? Oh, well, then we're going to give you all a chance to do that.
Oh, they did, but I went in there and I decided to bring it to court.
No, you're going to talk. You're going to take some time, and that will help you clarify what this is all about, too.
So, like I said, Your Honor,
I'm going to take a break and give you a chance, but that'll at least help you clarify. You're telling me you don't even know what it's about.
well, I do according to
And
these
so,
court papers.
I'm not going to have a trial right now. I just want to give you all a chance to talk
I don't
and
want to
figure
do
that
that, Your
out.
Honor. I honestly
Give it
don't
a
want to do
shot.
that.
It doesn't hurt
I
you.
already tried, and I don't
When
want to
did
do
you
that.
try?
I do not want to
With
do
Dispute
that.
Resolution Center?
I do not want
With
to
a
do
mediator?
that.
Why not? Tell me
Because
why not.
this is not true. None of this stuff, other than a damaged offense, is the only thing
Can I
that
ask?
I'm liable for.
All right, I really want you to find out what your issues are, and then you'll hone them down and come back to trial, and we'll know what everyone's talking about. The other thing too, I'm worried is that
I do not
Mr.
want to do that.
Staten, I'm also worried that you got a lot of information there, and you probably think that's
No,
important.
all I got's receipts.
Okay, they're probably important to defend your case, or not, or because whatever you have there, we have to make sure that Mr. Orsak knows what it is, and the court needs to have an opportunity to look at it. So
I'm just going to sit in there and stare at a screen. I'm not discussing this. I want to go to trial.
So how old are you, Mr. Staten?
63.
All right, you're not 12. You've done a lot of things in life. I bet you've solved a few things
I
by
disagree
talking to
with what
people.
I'm being sued
Right,
for.
yeah, everybody disagrees with
And
they're
I'm not
being
going to
sued
settle it
for.
with a mediator.
You
because
never know.
I'm not agreeing to $8,000 I don't have.
You're not, that's not what happens in dispute resolution.
No, I'm not doing
Yeah.
it.
Well, that's not what happens.
I'm sorry, but I'm not.
Why are you sorry? Do you wish you could? Have you settled things before with talking to other folks?
No.
In your life, you've never done that, ever. You've never.
Which is number one, wrong.
So, all right, Mr. Orsak, you need to unmute. I can't hear you. Mr. Orsak?
Yes, Your Honor.
Yes, so I guess we'll go to trial. I'm sorry that folks don't want to take their own opportunity to figure this out. But that's an aside now, that's done. So we put you under oath. Again, so Mr. Staten, if there's information that you have there that you want.
This is the state.
You jacking me around and railroading me through the trial.
Daryl G of case 161385 DS. Mr. G is here today after failing to appear before referee Snyder on September 5th, 2023.
I was muted.
Bond is currently set at $5.
I just said, let's end this on the low, shall we?
This is the 5th bench warrant. He reports no employment. Last payment made on this account was in March of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on July 24th, 2024 at 8:00 a.m. before this court.
Mr. G, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on July 24th, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not, but I do have a job lined up, which is probably not gonna happen. Thanks to everybody, but that's cool. I can't pay what I don't have. I don't know how many times I gotta say this. And as far as me missing the bench warrants and stuff, I'm basically homeless. So my address changed.
Well, you have to change your address with the front of the court.
Yeah, exactly. I know
If you
it's my
don't change the address, it
responsibility.
gets sent to the other address.
I know it's my responsibility to change my address, and it's up to me. It's my fault if I don't. But you gotta think, I'm sleeping underneath a bridge trying to go to work at Arby's. So it's kind of hard for me, to make it down here, inform y'all informally, and like I got a car and a house, and I'm trying to avoid paying y'all. So I would love to pay y'all. I would love to pay y'all so y'all can leave me alone. And like it's not like it's a lot of money here. It's a couple $100. But the notices I did not get, said I love my children. I see my children all the time. Now we could work out some way where I can go, because I got other cases pending right now to where I could get out and possibly still get my job. That would work out perfect for everybody. You get paid, I get a job. You know what I'm saying? Everybody happy.
We won't get paid, sir. You haven't paid in over a year. So
I haven't paid a year?
You haven't paid in over. You haven't paid since March of 2023.
I've had jobs. I've had jobs.
What I'm going to do is I am going to reduce your bond in hopes that you could be released, but I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
Is that cash or surety?
That is cash. That is correct.
Is the cash or surety or just straight cash?
No, it's cash.
I won't be able to pay that.
Okay, well, we'll see you back on the 24th then. Have a good day.
On the 24th?
Yep.
On the 24th, what am I being seen for?
You're seen for civil contempt of court for not paying your child support.
So what's going to happen to me then?
I don't know what's going to happen to you then. We have to wait for the hearing. You could be be in jail for 45 days if it's a first offense, or up to 90 days if it's a second offense.
So how much would I have to pay to not do the 90 days?
Well, that's all going to be decided on the 24th.
Okay, now keep in mind, I'm sitting in jail.
Sir, you're free to
There's
go.
no way
I'm not
I
going to
can pay.
engage in discussion. We'll talk on the 24th.
Yeah, we'll wait. Go ahead. I ain't got enough time. Thank you, though.
Well, there you have it. I could try to grab the Alec Baldwin thing, but I don't know where it is. Let me see. Is this it?
The live, with the ammunition.
Seth and Phil went to Yellowstone 1883. And he was teaching people how to shoot with these rounds.
Right.
Then they left.
Is
They
it?
went together from Arizona. And then they came back and went to another set, which was,
Sir, why does your video end there?
Because I walked out of the interview and was attempting to, or I did contact Detective Hancock to see who this individual was and why he was there turning in evidence, like he called it.
Okay. Did you know what it was evidence of?
He'd mentioned that it was tied to the Rust case.
Well, did he say in the video that it was not from the set of Rust?
No,
You didn't hear him say that?
I don't recall him saying that.
Yeah, I stopped it and I asked you what he said. Do you
Oh, I'm
remember
sorry.
giving that testimony?
Yes, I'm
Okay.
sorry, yes.
So the gentleman said on the video, it was not from the set of Rust.
Yes,
Okay. And you called Corporal Hancock, right?
correct.
And do you recall the conversation you had with her?
Yes, I asked her, an individual is here, gave her the name. I said, he claims that he has evidence. How do you want me to proceed turning it in and documenting it? Or if she was available to come over and interview him. And at that time, you guys were still involved in the Hannah Reed case. So she was unavailable and she asked that it be documented and she would have to do further investigation onto it and interviews.
Okay. I'll pass the witness. I don't know if you have any questions.
Okay, is this the evidence that was not turned over? I don't know anything about this. It sounds like there was a Brady violation, which is bad.
You don't need it? Okay.
Good afternoon, sir.
Good afternoon.
The witness was in the precinct told you he was a retired police officer, correct?
Yes.
He offered to make a statement multiple times, correct?
Yes.
Told you he was a witness multiple times, correct?
He did mention that.
Yeah. Told you he had evidence multiple times.
He did call it evidence, yes, but we had to confirm that it is in fact evidence, which is why I relayed to Detective Hancock that she needed to conduct an interview with him.
And what did Detective Hancock say on the phone? Tell me everything about that conversation.
They were still at the trial.
The world's
and that
preeminent
she would
expert
follow up with him and
on worse.
the evidence. Well,
And that would have really messed up the trial, right? If they had taken that evidence and vouchered it and let anybody know, right?
Phrase that?
Would have messed up the trial, right?
I don't believe it was used in the trial because it was never collected on our investigation.
And when Ms. Popple comes into the room, or when your camera comes into the room, she says, I've dealt with this case a lot, right?
Yes.
And Teskey says, you're the perfect person, right?
Yes.
And it was obvious from the conversation that Ms. Popple knew who Joe Swanson was, who Seth Kenny was, right?
Yeah, she was familiar with them.
Yeah. And that interview of him continued, correct?
I believe he was speaking on his own accord. We weren't conducting an interview. He was just there to turn in the evidence that he claimed he had.
Oh, that's not that. So that's testimony, sir, that if law enforcement is sitting with the witness and the witness is giving information and law enforcement's asking questions and the witness continues to give information, that's not an interview?
Law enforcement wasn't asking questions. That was our crime scene tech.
So ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant, as it pertains to me, needs to come out in the public.
All right, so you're calling yourself as a witness.
And I am, And it was my understanding that the court indicated to me previously that you wanted me to testify. I understand you've now changed your mind. I think it's a good idea if I do it. Where would you like me?
Oh, this
You want me
is
here at the
wild.
podium? No, on the Okay, sure.
I've never seen this happen. I've never seen this happen.
All right, Ms. Morrissey voluntarily calling herself as a witness without
No.
any requirement by the court to do so, or Mr. Spiro asking her to. Please raise your right hand. Do you swear affirm under penalty of law that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead.
During my investigation of this case and my review of the evidence in this case, I came to understand that there was a large batch of live ammunition that was in the possession of Thel Reed, Hannah Gutierrez's father. I also understood from all of the evidence and testimony that a portion of that batch of ammunition that belonged to Thel Reed was taken by Thel Reed and Seth Kinney to the 1883 cowboy training camp. When that was over, leftover ammunition was taken back to PDQ props. Seth Kinney took some of the ammunition from that container that he had brought back from Texas and turned it into the sheriff's department. And it appeared to me that he did it to try to exonerate himself. They took it from Mr. Kinney and they tagged it into evidence under the Rust case. Law enforcement then executed a search warrant at PDQ props and they took the entire container. And I will say that I do agree, as I recall, although I don't have it in front of me, I do agree that the search warrant didn't really require law enforcement to take everything, but it was my understanding that Mr. Kinney gave them everything so that they would have it and could tag it into evidence. Portions of that ammunition were then sent to the FBI for testing so that they could be compared to the live rounds that were found on the set of Rust. The FBI testing demonstrated that the live rounds that were taken from PDQ props that were originally in Texas did not match the live rounds on the set of Rust. And that's testimony that we heard during the Gutierrez trial. So what ended up happening was Mr. Bowles, Ms. Gutierrez's lawyer, put Mr. Teskey on a witness list and was intending to call him as a witness to the Gutierrez trial. I conducted a pretrial interview of Mr. Teskey, and I want to back up. I did at this point have some understanding that Mr. Teskey had had contact with law enforcement regarding these rounds that he still had in Arizona. So these are rounds that never left Arizona. They were always in the possession of Thel Reed and Troy Teskey. They never went to Texas. They never came to New Mexico. That's what all of the evidence indicated. So I understood that Detective Hancock had communication with Mr. Teskey about trying to get those rounds, and Detective Hancock was unable to get those rounds from Mr. Teskey. I did not find that particularly concerning because those rounds had never left Arizona. The filming of Rust was in the state of New Mexico. And the rounds that were taken from PDQ went from Arizona to Texas to Albuquerque. So ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant evidentiary value. Then, and I will say, I believe I actually saw a photo of it. At that point in time, I was able to look at the ammunition myself, and it was visibly dissimilar than the rounds from the set of Rust. We then cut to November of 2023. Mr. Bowles has put Mr. Teskey on a witness list for the Hannah Gutierrez case. We conducted a pretrial interview with Mr. Teskey on November 2nd of 2023. At that point in time, he brought up that he was still in possession of these live rounds that were Thel Reed's live rounds that had never left the state of Arizona. I then, when he started, I think he indicated during the pretrial interview that they were from the same batch that was sourced from Joe Swanson. And I then said, we should get those from you. I had a conversation with Detective Hancock after that pretrial interview about how we could get the rounds from Mr. Teskey, and we were trying to figure out if we could send a local law enforcement agency to pick them up. I was then decided that I needed to.
Okay, I haven't watched any of this, but could somebody tell me why the hell this matters to the case? I don't care where the rounds came from. He pointed a gun at somebody and pulled the trigger without checking. That's what he's charged with. I mean, it sucks that they didn't turn over evidence, but whatever. I'll keep it going now. But I'm confused on that, and that's probably just because I haven't watched it.
Figure out if that was necessary, since they had never left Arizona, and up to that point, It was my impression that they did not match the live rounds from the set of Rust. I then, as I recall, reached out to Mr. Bowles. He and I had a conversation about whether or not the rounds should be tested by the FBI. And I was still trying to figure out if I could get the rounds from Arizona to New Mexico. So I asked Mr. Bowles to please send me a photograph of the rounds from Troy Teskey so that I could see with my eyes whether they were even remotely similar. If they were similar, I could go through the steps of obtaining the ammunition, connecting probably with local law enforcement, having a local law enforcement agency go to Mr. Teskey's residence and collect them. I didn't want to do that if they didn't look anything like the rounds from the set of Rust, because all 6 rounds from the set of Rust are identical to each other.
Yeah.
So when I had this conversation with Mr. Bowles, he provided me the photograph that I showed this morning. And this is it was my understanding that this was a photograph from Troy Teskey. So Troy and I don't communicate. He's a defense witness.
I've watched none of it.
With a defense witness. So Mr. Bowles, as I recall, texted me this photo, and this is a photo that Mr. Teskey took at my request so that I could determine whether this ammunition was related in any way to the set of Rust, because it never left the state of Arizona. So if it never left the state of Arizona, the only way that it is relevant to the Rust investigation is if it has any similarity to the live rounds that were found on the set of Rust, because we were at that point trying to figure out the source of the live rounds. When I received this photograph from Mr. Bowles, I could immediately tell that these are very dissimilar from the live rounds that were found on the set of Rust. They have brass primers. So this is what was presented to the prosecution as the rounds that were in Mr. Teskey's possession. They have brass primers and not silver primers. One of them, the one on the left, appears to be a Starline brass casing, but they have truncated cone projectiles. We had seen ammunition that looked exactly like this, not exactly, but very, very similar. And that ammunition was the ammunition that was collected from the sheriff's department and went to the FBI for testing and was determined not to be similar in any way to the live rounds on the set of Rust. So when I saw this photograph, I could see that it was not at all similar to the live rounds on the set of Rust. And I decided not to take any steps to collect this ammunition because it was in Arizona, had never come to New Mexico, and didn't match the live rounds on the set of Rust. So what ends up happening is Mr. Teskey is called to New Mexico by Mr. Bowles to testify at the Gutierrez trial. And you can hear on the video that the court heard Mr. Teskey say, the defense attorney, that's not me, asked him to bring samples of that ammunition. According to Mr. Teskey, he brought the samples of the ammunition, showed them to the defense attorney, and the defense attorney said, I don't want those. I'm not going to use those. And by the way, I'm not going to call you as a witness. So Mr. Teskey sat in court during the trial. And then at some point, contacted the deputies downstairs and said, I have this ammunition. So he tried to give it to the defense attorney, who's the person who asked him to bring it. The defense attorney said no. And he then tried to get a hold of Detective Hancock, who was not available because she was with me. So then he ends up going to the sheriff's department and he leaves the ammunition at the sheriff's department. I was contacted, I don't think it was the same day, but I'm not 100% sure. It's possible that it was, by Detective Hancock, and she indicated that Troy Teskey had dropped off ammunition at the sheriff's department. Because I had already asked for a photograph of it, I believed that that ammunition was going to look like the photograph that Mr. Bowles had sent me. Corporal Hancock indicated that she was going to tag them in evidence. She was going to create what she called a doc report. And I said, great, do that. I was not aware at that point in time that a doc report would not have the same case number as Rust. I was not aware at that point in time that it would not be linked to the Rust case number. I understood that he had dropped off ammunition that I believed to not look similar to the ammunition from the set of Rust. And I had no idea that it wasn't going to have the same case number. I want to show the court, though, when Mr. Teskey showed up to testify with the ammunition that Mr. Bowles told him to bring to the state of New Mexico, he was not called as a witness, and Mr. Bowles said, I'm not taking that ammunition from you. That's why. Because these are photographs from Hannah Gutierrez's cell phone extraction, and they show spot on match for the live rounds found on the set of Rust. This is clearly the reason that Mr. Bowles said, you and your ammunition better get out of here, because it would not have hurt the case, the state's case against Hannah Gutierrez. It would have been the best evidence I could have hoped for. These look exactly like the ammunition, the actual ammunition that we have in evidence. And they do look like the 3 rounds that are in that envelope. So when Mr. Teskey couldn't get Mr. Bowles to take them because they were the best evidence against his client, he took them over to the sheriff's department. And when he dropped them at the sheriff's department, I was told that there was going to be a report. There was a report. I assumed they looked like these. And Detective Hancock indicated to me that because he dropped them off and he didn't wait for her, she was then going to try to follow up with him, take a statement from him, so that we could get some idea where they came from, what the relevance was, if there was any relevance at all. And he never returned her phone calls. And that's all of the information that I can give the court, but I'm happy to answer any questions.
May I ask a few questions, Your Honor? When you took over this case, the investigator handling the case, Mr. Schilling, left the case, correct?
At my request, yes.
The paralegal that was handling this case with you
This is
left
insane.
the case, Mr. Tad.
At my request, yes.
Well, the first prosecutor that was working with you on this case, you selected, correct?
I did.
And he resigned too?
I wouldn't say that he resigned, no.
Okay. He didn't stay on the case for the Alec Baldwin trial, correct?
No, and he indicated that that was because he represented a labor union that's a national labor union, and he was not expecting the trial to be set so quickly. He wasn't expecting it to be set in July. So when he realized that the trial was going to be set in July, he was going to be in collective bargaining agreements for his national labor union, and he wasn't going to be able to have enough time.
Erlinda Johnson, the next prosecutor selected, resigned from the case today,
She did.
based in part on the conduct we're here discussing, correct?
I believe that Ms. Johnson Ms. Johnson didn't want my understanding is that she didn't agree with the decision to have a public hearing.
On July 1st in this matter, you served a certificate of compliance with 5501, correct?
I did.
And you've never turned over the report or any of the evidence that we're talking about here at this hearing, correct?
Let's take it one at a time. I did not turn over the report. I didn't have a copy of the report. The rounds that were left at the sheriff's department by Troy Teskey, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Bell Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case?
I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the sheriff's department. But you are right.
And you concede that they are Starline brass silver 45, right?
I can. And this is the best evidence against Hannah Gutierrez.
Yeah, you've said that a couple of times. Any favorable evidence you understand as a prosecutor has to be turned over to the defense, correct?
I do.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to turn that over in this case as well, correct?
And let me give you a full answer to your question. When the second Hague report came in, and I provided all of this to the defense, I sent it to the person who is managing the Discovery server and asked them to upload it. It wasn't until I realized during pretrial interviews that it wasn't there, that there was a problem with it. So I then attempted to figure out what the problem was, and it was indicated to me that it appeared that the former paralegal who was working for the special prosecutor had removed it. So we then immediately provided it. Then during the pretrial interview of Mr. Haig, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine, and that was provided immediately. I went back, I checked my email, I could see that I received it from Mr. Haig and failed to forward it on to be uploaded. And I provided it as soon as I was aware that you did not have it.
The fact that nobody at the Hannah Gutierrez retrial cross-examined Mr. Haig about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case. So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Haig at that trial that was inconsistent, at least partially inconsistent, as the court's aware, with his third report, correct?
Tell me what you're referring to and I'll answer your question.
Well, there was a whole hearing about this where you saw this and you saw me go back and forth with Mr. Haig for 25 minutes. So
I agree, but I need to know what you're talking about for me to answer your question.
Okay, if you can't answer the question, you can't answer the question. I'll move on.
I'm happy to, but
you say that the extent of the communications you have about the doc report, as you relay it to the court, is that all you said in response was, "Great, do that." That's your testimony?
yeah, I assumed that it was going to be tied to the same case number. So I said, great, do it, file a report.
No follow-up questions?
No, because I had a picture of the ammunition that didn't match the ammunition from the set of rust.
No concerns in your mind when you got the case file and you turned it over to us and it wasn't included?
Absolutely not. There's a terabyte of discovery. I didn't know whether this 2-page police report had been provided. And in addition to that, I had no reason to believe, and still have no reason to believe, that those rounds have anything to do with these cases.
As I asked you about Mr. Haig yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false?
What part of her testimony was false? And I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you, and I didn't realize that there were rounds that looked like that.
It's okay. In any event, when the court, and you never tested those rounds either, correct?
Any of the rounds that came from Mr. Teskey? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these. I've never seen these. And I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appear to be similar to rust, yes.
Well,
I never saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right, but don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teskey had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
don't you think it was misleading to this court to not just say at that point, just so you know, I know about this. I knew about this then. I was involved.
I did not intend to mislead the court. My understanding of what was dropped off at the sheriff's department is on this computer screen, and it looks absolutely nothing like the live rounds from the set of Rust.
The truth of this matter is you don't like Mr. Baldwin very much, do you?
That is absolutely untrue. I actually really appreciate Mr. Baldwin's movies. I really appreciated the acting that he did on Saturday Night Live, and I really appreciate his politics.
You told one of the witnesses who disagreed with you during an interview that you thought Mr. Baldwin was a cocksucker.
I do not recall saying that. I know that that was something that Mr. Baldwin would say on the set of Rust. I don't recall saying that.
Do you deny that under oath?
Without having more information, I can tell you that I do not recall ever saying that. And if I did say it, I invite you to point it out to me.
You called him an arrogant prick to another witness.
To who? To what witness?
I'm asking you, did you call him an arrogant prick during a witness interview?
I don't believe I did. I don't recall.
Do you deny that?
Without knowing what you're talking about, all I can tell you is that I can't respond if I don't know what you're talking about.
And you said also to witnesses that you would teach him a lesson.
I never said to witnesses that I would teach him a lesson. Absolutely not. In fact, Mr. Spiro, I want to give a full response to your question. I made every effort in this case to resolve this case with your client in a very favorable way for him.
All right, I'm going to move to strike this. It's not responsive.
It is
Well,
responsive.
I don't want to talk about plea negotiations.
Yeah, and it's not responsive. So I have no further
All right,
questions.
do you have any follow-up testimony? All right.
I want to say I have no recollection of calling him any of those names. I have invited the defendant to tell me what he's talking about, and he has declined. I want the court to take notice of that.
Thank you. You may step down. All right, any other witnesses?
No, Your Honor.
All right, argument, let's not, 15 minutes aside sufficient?
I don't even think that is necessary, frankly.
Do you want to make argument?
Further argument.
All right,
I don't think either side needs further argument on this.
all right. So dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element and I have to make a very good record as to why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld the supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated, State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted. Now, with respect to the jury, I don't imagine you all want to return on Monday. I will take care of the jury.
Thank you.
We are in recess.
Wow.
I'm not getting it. I'm gonna.
Dismiss him, Judge. Dismiss him.
Go ahead.
Wow. That's wild. I've never seen an attorney take the stand in the middle of a trial. I've got issues with my green screen. I've never seen an attorney take the stand in the middle of a trial and get cross-examined by opposing counsel. That's crazy. The only thing there is I have no context. I've not watched any of this. None of it. None. Clearly there was material that she knew about, namely a report that she didn't turn over. The only thing, and I don't do criminal stuff, that strikes me as kind of odd, or the prong that the judge said, and I'm not disputing it. I'm just saying I don't understand it. Is she saying, would the evidence have helped the defendant? And I don't see any reason where this evidence would help the defendant. But I don't know enough about the case. There could be. I'm just saying, as I watch this snippet of it, I do not understand how this evidence would help the defendant. He's charged with what? Involuntary manslaughter, and basically, it doesn't matter where the hell the round came from. Nothing about the rounds matters at all. Did you check the gun before you pulled the trigger? No? Okay. Then you meet the elements of the offense. So there may be... Stop it, Iris. There may be really good reasons. I'm speaking out of context because I have not watched any of this trial, but I just intellectually do not understand how this evidence makes one whit of difference to the defense. I understand that they withheld stuff that they shouldn't have, but what I'm going on is the justification for declaring a mistrial. There may be really good reasons why this evidence. She was saying that they could use it for impeachment. Somebody may have offered a theory that that's inconsistent with, and then that would make sense. That's where I don't have all the context. But just watching this in a vacuum, I look at it and think, so what? Not so what, like it's not a big deal, but like I don't see where you dismiss with prejudice, if that's the standard in New Mexico. But she did. She did. It's hard too because I didn't watch the trial. I could see enough of this prosecutor. She's hard to like. It's all over my chat, and I understand that, but a lot of that's personality. Her personality is it's grating. I'd say I can't put my finger on it. I can. I don't want to say why, but it is. I don't want to take the heat for all this stuff. We just like to have fun here and have some laughs. I know why she's irritating, but we're not going to get that deep here. We're not going to, and damn it, we're not going to learn anything. We're not going to learn anything. I didn't even watch the trial. I'm sure, you know what I would do? I would go and watch Runkle's channel because he actually knows about this stuff. Or I can't think of their names right now, but there's a few other there are a few other people out there who actually know what they're talking about with this stuff. I defer to them. I thought it was that was fascinating to me just to see a prosecutor call herself as a witness and get I don't know how you can't proceed with the trial after you do that anyway. You can't be a witness in the freaking trial. And the judge knew she was dismissing it because she had her law clerk, whatever, look up all the stuff for how to dismiss this thing. I don't know what context we're in, but if we're in mid-trial, that strikes me as odd. If this guy's making no motion to dismiss on a Brady violation, this judge looked like she had this all briefed and ready to rule this way. I have not had one White Claw. I haven't had anything to drink. I'm being a good boy. Well, that was actually kind of fun. Thank you, chat, for dragging me into that. That's the best part of the trial. I thought about doing that trial. I just didn't want to be chained to it 8 hours a day for however damn long it took. Although when you get this, if I would have known we would have had this blow up and the trial didn't go very long, I probably would have done it. All right. Yes. Mindy was the first one for me to chat about that with. Went back and forth on IG. I assure you, I've seen not one bit of it. We did a stream on it like way before, like before they rebrought this charge. In the first case, it was on a stream with, I think, on Law and Lumber with Ian and Rob, and we talked about the case. I still didn't know anything then. But that's the last time I really focused on it. All right. Good times. It's Friday night. Behave yourselves. I'm not bailing you out. Thanks for coming on. I'll see you soon.